Good evening, everybody, and I would like to welcome you to tonight's first Heilbrunn lecture from the team of the Next 100 Years project. My name is Dana Dennis-Smith. I'm the founder of the first 100 Years campaign that celebrated last year the centenary of women in law and their journey since 1919, when they were finally able to join the legal profession. I'm delighted to welcome tonight to introduce our series of lectures, Lady Arden, one of our justices of the Supreme Court, the third woman to join the court, and to say a few words about tonight's lecture and about the series. And we will then continue with tonight's program. Thank you.
Good evening, everybody, and thank you, Dana, very much indeed for that warm welcome. What a pleasure it is to be here. I wanted to use this opportunity to say just a very few words about Rose Heilbron and what she meant to me. It's in her honor that these lectures have been dedicated. Kirsty, I know, will do more than anyone to perform the task of honoring her memory. But I want to explain just briefly what she meant to me in my career. She was my role model. And I want to give you some points about her to take away. When I first heard about Rose Heilbron, I was still at school, and she was well into her career as a practicing advocate in Liverpool. She had broken the mold, and she was a top-class criminal advocate. Everybody knew her in Liverpool. We had hard copy newspapers which came morning and evening, and for very many of those evenings on weekdays, the headline would be something like, "One word from Rose and the killer goes free." She was just very well known. In later years, a wonderful portrait of her was done and commissioned by Gray's Inn, which is to be found there, and which very much reminds me of her. But in the time available, I thought I would make just 3 brief points about her career. The first is, of course, she was the most successful trailblazer. 1949, first female KC alongside Helena Normanton. 1950, first woman lead defense counsel in a murder. 1956, first woman recorder. 1972, first woman to sit as a judge at the Central Criminal Court. 1973, leader of the Northern Circuit. In 1974, appointed a High Court judge. And after that, she chaired the important Heilbrunn Committee, which reported on important reforms to the law of rape. And then she became first female treasurer of Gray's Inn. And on her 80th birthday, I recall that there was a birthday dinner for her, which I attended. And there was this amusing story about one of her addresses to the jury. She addressed the jury saying, "Gentlemen of the jury, I hope that you will retire with the words of the defendants ringing in your ears." The judge was Donovan J. He started his address to the jury. "You've heard what Miss Heilbron said, that when you retire, you should hear the words of the defendants ringing in your ears. Gentlemen of the jury, I hope you have no such disability." But my second point is that her experience was the experience of almost every woman who tries to succeed in a man's world. She suffered daily indignities, and to which she responded with great dignity. For example, as I understand it, when she became leader of the Northern Circuit, she had difficulty being admitted to the mess and attending the dinners. But one small example was given to me by a fellow Liverpudlian, Sir Michael Morland, who became a High Court judge. And he explained to me that one evening he was sitting in a restaurant and noticed that she was dining on her own. And 2 barristers then got up and joined her for dinner, and that this was the start of breaking the ice and having a woman in their company. And so the story I tell you is just to show you that how important just a small act of kindness can be. And the moral is, never refuse a small act of kindness. The third and last point I want to make is that she must have had enormous resilience. She must have had great difficulty in getting herself accepted despite her obvious success. Now that was over 50 years ago, and I think things have probably moved on a great deal since she was at the bar. But it seems that it now is much easier for women to get accepted as a member of an organization. But there are still difficulties for women that I hear about. And so I would like to say this: diversity is just more than getting invited to the party. It's also about being invited to dance. And may you look back on the career of Rose Heilbron with pride, but remember there are still battles to be won. Good luck, and sit back and enjoy Kirsty's lecture. Thank you, ladies and gentlemen.
Thank you so much, Lady Arden, for your wonderful words about Rose Heilbrunn, but also about the journey of women in law. To bridge our previous project to the next 100 years project, I thought it might be a helpful reminder to play a little film about the impact the first 100 years has made on the legal profession. It's just 1 minute. So as you can see, and hope you will remember some of these special moments we had last year and for the last 5 years with the first 100 years. As you can imagine, we discovered part of our research and our work, one of the biggest gaps that needed to be filled, and that was creating a public platform for the brilliant minds of women to display their expertise in the legal profession. We came to realize, having done a little bit of research on the lecture circuit in the legal profession, but beyond as well, with obviously the most famous of lectures being the Wreath lectures from the BBC, that women are significantly underrepresented in these important platforms. And so we created a new lecture series to fill this gap. The plans for our lecture series are certainly as ambitious as those of the Wreath lectures, can I say. We never do small projects at the Spark 21 charity, and with the next 100 years, we hope to really make an even bigger impact that we have already managed to achieve. In the Wreath lectures, for example, only 7 women out of the 72 years of the existence of the lecture series have been filled by women. So our plans really are to advance public understanding of very big themes, but through the perspective and through the voices of female legal experts. And we settled actually on the theme for this year, on freedom, before we all found ourselves in confinement. What foresight we had when we picked our theme. Little did we know what things were to come. So there's no better way to start this lecture series than somebody who has spent a good part of this year looking at freedom, looking at the coronavirus regulations and what have they done to us all. But I wanted also to reflect a little bit on Rose Heilbron herself and why we picked her name. And we are honored to be joined tonight by her daughter, who will address us later on tonight, Hilary Heilbron. Rose Heilbron was known, as we heard from Lady Arden, as a speaker who combines charm and elegance with intelligence. She was the orator of her generation, an incredibly hardworking woman with great talent that clearly had taken her to the very top of the legal profession. And she was the first in so many ways. She also had a very good sense of humor, I understand. And at one point she said that her work is very absorbing, but the press make it even more interesting. So I'm looking forward to hearing Kirsty's take on what the press makes of her career and her stance on recent events. Kirsty, a little bit like Rose as well, is also a member of Gray's Inn and a bencher at the inn. She was the winner of the first 100 Years Inspirational Woman Awards in the Barrister of the Year category a couple of years ago. And she is described as a superstar, fiercely intelligent, very good and very charming, and also has been reported to have delivered the best closing speech I have ever seen. So I also love the fact that Kirsty has incredible versatility in her lecture topics, from climate change to the Colombian peace process, but also is a regular speaker on witchcraft. So without further ado, I'd love to welcome Kirsty to give this lecture on love, law and government in the times of coronavirus. Enjoy.
Thank you very much for that introduction. Well, Lancashire is the county of moors and rivers, black pudding and Lancashire crumbly cheese. My family worked in its mills, factories and coal mines. I was starting school near Chorley when Dame Rose Heilbron became leader of the Northern Circuit. I didn't know of her or her achievements until much later, but somehow I think our shared breathing of the air of the Northwest fills the space of the decades that are stretched between us. It's a real honour to be invited to give this lecture. I call my parents at the weekend. They still live in Lancashire, near Chorley. My dad said, "There's a grey lag or a pink-footed goose," I always get the two mixed up, lying dead at the bottom of our garden. Apparently, he continued, there have been swans dying in the area. And so DEFRA is coming to collect the goose and they're going to analyse it. Also over the weekend, a colleague contacted me in relation to his daughter at Nottingham Trent University. She had been issued with a confusing standard letter from Nottinghamshire Police indicating that a fixed penalty notice or possibly prosecution would be coming her way. She'd been in another student's shared accommodation in the floor above her own accommodation in the same block, but numbers had been over 6, probably around 10. They were within a group of students who regularly mixed together, and the police attended and substantially, undoubtedly added to their numbers. I spoke to her, an 18-year-old, starting off on a life, a career, living independently. She told me that there was no prohibition on students all congregating in the same laundry room, and that the police had come into the flat, that they'd taken her photograph as she wasn't carrying any ID. We spoke for some time about the stress to young people who cannot afford fines. She said to me that the police had not asked her to return downstairs to her flat, instead of issuing her with a letter saying that she very shortly would be receiving a notice, or possibly worse, a summons to be prosecuted. She would have returned to her flat if she'd been asked. We started 2020 seeing images everywhere of Australia's koalas, the creatures that inspired the Aboriginal people's Dreamtime stories and spawned a world market in children's toys and cartoons. But this time, the images were of them bloody, singed, or dying, or worse, much worse, and helpless. They were too slow to flee the bushfires which have been raging since September 2019, and they have joined the nearly 3 billion animals killed or displaced by the mega fires in Australia. 3,000 million animals have died or been displaced. That's almost half the human population. And 2020 then evolved and mutated into the year of breath. Human rights have been stripped to an essence of breathing, from the cries of George Floyd's "I can't breathe," to the protests of Extinction Rebellion against climate change, to the fires raging through the Earth's lungs in Brazil's Amazon rainforest, to the respiratory disease induced by COVID-19. It might have seemed to many that nature, in the midst of its own suffering, has struck back, has forced humans to take their own collective breath, as COVID-19 led to shutdown, traffic stopped, and airplanes grounded. But into this stillness, we saw emerging government control through emergency laws. Now, the laws, what are they and what were they? Well, the health protection coronavirus restrictions, regulations, are the regulations which prohibit movement. And there are regulations for England, Wales, Scotland, and Northern Ireland. I'm going to speak mainly about England. There's secondary legislation under the Public Health Control of Disease Act 1984, and this means that they were introduced without going through Parliament under the emergency procedure under that Act. They came into force on the 26th of March 2020, and they had to be reviewed within every 21 days. So what we've seen has been a series of amendments, regulations, new regulations, and repeals of the old regulations. There are similar regulations for Scotland, Wales, and Northern Ireland, but there are also differences. The latest are the all tiers regulations. They were published yesterday and are enforced tomorrow on the 2nd of December. They are lengthy and they are complex. At the same time, going back to the 26th of March, the coronavirus 2020, this is primary legislation, came into force. The Coronavirus Act introduced powers relating to potentially infectious persons, those who are or may be infected or contaminated with coronavirus, and there is a risk that the person may infect or contaminate others with coronavirus. It is the public health regulations that introduce the powers that have restricted our way of life, our movement, our work, our business, our worship, our gatherings, our family life. They have changed our lives, the way that we live with our family, with our friends. They are the most draconian restrictions on our liberty since World War II. And generally, these laws have been posted online with little time before they came into force. We've seen laws uploaded in the middle of the night, on one occasion allowing only 30 minutes for people to read and understand them before being subjected to them. This in itself raises its own questions on legality, because the law must be accessible and clear to people, otherwise the law itself is not lawful. It took rebellion from Conservative MPs and a scorching speech from the Speaker of the House, Lindsay Hoyle, who happens to be an MP for Chorley, on the 30th of September 2020, for Parliament to start having a voice. Lindsay Hoyle said, "The way the government has exercised its powers to make secondary legislation during this crisis has been totally unsatisfactory." He called upon the government to stop treating Parliament with contempt. Thomas Hobbes considered that in a world without law, the life of man would be solitary, poor, nasty, brutish, and short. But laws themselves are not a solution. As has been shown, they can be part of the problem if they are not just, clear, and accessible in substance and application. As living as we know it has been paused, the government has settled into ruling by decree. To date, it has laid 304 coronavirus-related statutory instruments before the UK Parliament. So this means that, in particular, since the 6th of March 2020, the average rate has been 8 per week. The result? Well, the result has been unclear, unjust, and arbitrary legislation. Errors that might have been picked up in parliamentary debate have been exposed through practical illogicality. And the Prime Minister and ministers have added to the fog by giving the impression that announcements were law and that guidance was law. And the guidance historically has actually been stricter than the law itself, and the guidance was never and could never be legally binding. This hasn't been helped by referring to law and guidance as rules, as if we're all engaged in a nationwide game of rugby. A study found by the authors Halliday, Mears and Tomlinson that whilst 99% of people surveyed claimed to know what activities were permitted under the law during the first phase of lockdown, 94% of them erroneously thought that intentionally coming within 2 meters of someone outside the home was prohibited by law. There has never been such a legally binding prohibition in England. The restriction of exercise only once a day was never a legal restriction in England. However, it was in Wales. Then we had as well that the government announced a relaxing of the regulations on the 10th of May 2020. The Prime Minister announced, we want to encourage people to take more and even unlimited amounts of exercise, omitting to clarify that there was no legal prohibition in the first place. He added, you can drive to other destinations to take such exercise. There was no legal prohibition on doing that. People either were concerned not to do something unlawful or were unsure and so did not want to risk it. And this overstating of what the law was inevitably impacted upon the most vulnerable. And even just upon those who are normally law-abiding, those who would be stressed by a parking ticket. Criminal enforcement is a frightening concept. So this mashing together of government announcements, public health guidance and law has led to consequences which should have been foreseen, they could have been foreseen. It's led to unlawful enforcement, and it's ongoing. The first publicised conviction under the coronavirus emergency laws was in Newcastle. A woman was arrested at Newcastle railway station. She was reported as being there loitering. She was standing on her own at a station. This was in the very early days of the first lockdown, and perhaps is an indication of the kind of fear that was rippling through society. She was convicted on the 30th of March 2020 by a district judge. The case was referred to me by a very conscientious and diligent young journalist, Faria Karim, for the Times. She had asked the right questions of the British Transport Police, who had publicised somewhat boastfully that they were responsible for the first conviction under the coronavirus laws. But what is the charge? Faria asked. The charge was that she had been failing to provide identity or reasons for travel to the police and failing to comply with requirements under the Coronavirus Act, under Schedule 21 of the Coronavirus Act 2020. In summary, there's no such offence. Coronavirus Act, if you remember, is primary law which deals with the potentially infectious. She was not considered potentially infectious. The police were perhaps reaching around to look at the regulations, but again, it would have been highly likely that they would have applied. In addition to the British Transport Police arresting her, she was then detained in police cells over the weekend and then produced at the magistrate's court. There was no power to detain her in police cells. There's no power to detain under the coronavirus laws. She was falsely imprisoned. After a quick review under the usual publication deadlines that we have with national newspapers, the Times published the article that she had been prosecuted for an offence which does not exist. Very quickly, the British Transport Police accepted this and fully accepted that this should not have happened. They did apologise. The British Transport Police Deputy Chief Constable Adrian Handstock said, "It is highly unusual that a case can pass through a number of controls in the criminal justice process and fail in this way." Because, of course, she had been prosecuted by the Crown Prosecution Service on an offence that does not exist. She had been convicted by a district judge for an offence that does not exist. And she at the time was represented by a duty solicitor. Highly unusual. But similar cases followed. On the 20th of April, a young man in Oxford walking to an address where his mother lived and back to another address was arrested and prosecuted, this time under the Welsh part of the Coronavirus Act. As well as using the wrong law, obviously I proudly pointed out in what I hope isn't my career-defining moment that Oxford is in Wales. They used the wrong jurisdiction. On the 2nd of May, the Crown Prosecution Service announced that it was reviewing all charges and prosecutions under the coronavirus laws. It saw that there was a problem, and all credit to the CPS for doing so. At that time, 28% of people were found to have been incorrectly charged, with 18 cases having been prosecuted all the way to conviction and sentence. However, the Crown Prosecution Service's latest review shows that 48 out of 122 cases charged in September 2020 were either withdrawn or returned for the convictions to be set aside. So there is an ongoing issue with these laws being wrongly used and people being wrongly charged and wrongly convicted. What's the reason for this? Well, successive governments have overseen swinging cuts to legal aid, the court service and the Crown Prosecution Service. Battering the criminal justice system inevitably opens cracks through which the vulnerable fall. Some responsibility also lies with police chiefs who grasped their new powers under the emergency laws with messaging of flying drones to observe walkers and inspecting shopping to assess whether bare essentials were within the shopping. Martin Hewitt, chair of the National Police Chiefs Council, has written that there have been well-publicised instances of overzealous policing during the early part of lockdown. However, the continuation of wrongful enforcement 6 months later shows this to be a deeper issue. Nevertheless, there remains a stubborn refusal from police chiefs to review fixed penalty notices which have been issued under the same laws. There is an even greater likelihood that many of fixed penalty notices have been issued wrongly, as there is no oversight concerning them. There are none of those safeguards that were there for the wrongful prosecutions, and there is no appeal. And we're seeing this extension of enforcement using fixed penalty notices creeping around our universities as well as around other members of society. A review of fixed penalty notices should be actioned, focusing upon whether they were correctly issued and where there was evidence of a breach, whether issuing was a last resort. In other words, the discretion not to penalise people for a breach, particularly where there's been a low risk of spreading coronavirus, should be applied. Adding to this fog around the laws was the early example of Dominic Cummings, senior government advisor. He undoubtedly broke the government's own guidance in his travel and the famous trip on the road to Barnard Castle. As to whether he might have broken the law, the regulations at the time, the answer also is yes. Very briefly, the police looked back as to what they would, or they hoped would have happened if Mr. Cummings had been stopped on his journey to and from Barnard Castle. And they said this: the officer would have spoken to him and, having established the facts, likely advised Mr. Cummings to return to the address in Durham, providing advice on the dangers of travelling during the pandemic crisis. Had this advice been accepted by Mr. Cummings, no enforcement action would have been taken. Confusion, or possibly deliberate government spin, is sourced in this next part of the police statement. They went on, there might have been a minor breach of the regulations that would have warranted police intervention. Durham Constabulary view this as minor because there was no apparent breach of social distancing. To be clear, this part of the statement did not undermine the police's conclusion that they would have considered Mr. Cummings to have broken the law if he had been stopped, and given the account he gave at his press conference. Rather, the wording reflects that the police cannot determine beyond reasonable doubt that Mr. Cummings and/or his wife committed an offence. This is the remit of a court. Importantly, the police cannot consider enforcement measures unless they are empowered by regulations then or now. In other words, if they have a reasonable belief that an offence has been committed, best practice is to engage, explain, encourage, with enforcement only being used as a last resort. Obviously, Mr. Cummings would have been entitled to say, I'm not going home, I've done nothing wrong, I won't pay a fixed penalty notice, start a prosecution, let the court decide. Or he could have followed the advice and avoided escalation. The need for police to avoid issuing fixed penalty notices or commencing prosecutions is always particularly important if the offending is considered to be at the lower end of the scale. And Durham police back then emphasised what should have happened, with which I agree, but we seem to be going back again to police overreaching and for enforcement being overused. Durham police back at that time said, by way of further context, Durham Constabulary has followed government guidance on management of alleged breaches of the regulations, with the emphasis on the NPCC and College of Policing 4 E's: engage, explain and encourage before enforcement. This was not what was happening to people up and down the country. It's not what's happening now. None of the 4 E's seem to be considered to the student I spoke to at the weekend, who has her letter and is awaiting her notice for being in somebody else's flat with numbers over 6, no more than 10, when she could easily have been asked to walk down to her flat on the floor below. It is, of course, appreciated that it's difficult to achieve equal justice, and the law does not preclude there being discretionary powers. But at least where there is injustice, it should not be arbitrary. An equal distribution of benefits and burdens of law should be realised in actions by those empowered to enforce. The promulgation of laws is a fallacy without congruence between norms and application. In other words, attempts to achieve fairness, secure legitimacy. This is a fundamental flaw. Otherwise, the rule of law is reduced to an ambition. But where does this leave us as a society? As we hold our breath under our face coverings, a generation are growing up avoiding touch, associating fear with hugs. The law favours liberty. This is a Roman principle cited in English law reports since the 16th century. And yet the government continues to plant emergency laws between families and friends, restricting their freedom to move, to work, to worship, to socialise, to mourn, to care, and to love. In care homes, after an apparent initial disregard for the vulnerabilities of our elderly and frail and unwell, there's been a full swing the other way, where we saw families denied sight of their loved ones even, and denied contact through touch. There's a difference between public health guidance, I hope has been outlined clearly in this talk, and law. Public health guidance is important to follow, and laws undoubtedly are required to help prevent the spread of virus. And that is the aim, and that is only how regulations can be empowered, if that is their purpose. But whilst the vulnerable look to law for protection, society also consists of those who are capable of taking individual responsibility. The government should not attempt to control every aspect of our lives. And this is continuing to occur. On reflection in giving this lecture today, I'm not sure whether I'm speaking out of a bright desire to support the rule of law. It might be that I'm acting out of guilt at being at a table of privilege where my place was never set, bruised from a collision with the grey reality of how the COVID laws are being applied. Or it might be that we all of us are just fighting in our own different ways to give our loved ones, human and animal, more time on this earth, but also more time that is enjoyable and fulfilling, filled with love and emptied of loneliness, stress, and even hunger. But the further the government continues to empower fining and criminalisation of social behaviour, the less connection it has with the love that actually binds us as humans, with the human spirit, with humanity. It is time to clear the fear and to let us all breathe. Thank you.
Thank you so much, Kirsty, for a wonderful lecture. We are able to take a couple of questions before we progress our evening. So if you have any questions, please drop them into our Q&A on the Zoom call, and then we'll fish them out of there. We have a question from Margaret Owen, who is asking about what more can we do to help our sisters-in-law in the international context, where women are risking their lives protecting human rights in their everyday work. If you want to take one at a time, I think that's probably easier with this format.
Yes, the question is a very good one, because we all are living in our own reality. And it was said to me very early on, at the beginning of the various lockdowns around the world, that some are in an entirely different reality to those that we would experience, even the most vulnerable within the UK. And I have been in contact, for example, with a number of human rights lawyers in Colombia and a number of NGOs there, where many of the people who were suffering were actually more in fear of dying of hunger than they were in fear of dying of coronavirus. What can we do to support those internationally? We can connect, obviously, with various charities, and we see this. I think the positive thing that the pandemic has shown has been that human spirit of people working around the world, and particularly obviously looking nationally up and down the country, providing clothing, providing food to people, and we see that also internationally. And really what we can do is shine a light on those who are struggling, and to assist those and provide solidarity to those around the world. One aspect which I think is quite interesting is that perhaps the pandemic has brought some humbling to Western countries, in that what we have seen has been assistance coming to Western countries from countries such as China, from countries such as Cuba, which previously might have been dismissed by countries like Italy, by countries like the UK, as somehow being inferior in terms of how they are supporting people and their people, and in a lot of cases with absolute justification. Obviously, the human rights records in China is absolutely diabolical, and terrible human rights violations in Cuba. But what the pandemic has exposed is that there can be a connection globally, and that can be humbling for countries like our country, where we have always seen ourselves as leading in human rights around the world. And I think that is quite a good thing.
So actually a question that is following quite nicely from this point that came through is this difference between, say, the Chinese regime and but even the other Asian countries that deployed very quickly tracking of personal lives and technology to that effect. And we were wondering whether our expectation to a right to privacy is kind of getting in the way and has created this, situation where our freedom is so curbed. Is there a conflict between our right to privacy and public health, if you like, and what is your view?
Yeah, so the rights to privacy, so in terms of the European Convention, it's a qualified right. So your right to privacy isn't going to trump absolutely everything, and it's a matter of balancing and proportionality. And here the balancing exercise is considering the public health risk to people and balancing that against the interference with somebody's privacy. And this often is where it has been going wrong. And we are seeing now, for example, with fixed penalty notices, we are seeing sharing of data starting to occur between enforcement, such as the police, and then sharing of data with the universities. And this undoubtedly is only going to develop. Now, looking at that, how is that sharing of data actually assisting in combating coronavirus? One of my issues with much of this law has been that we have seen enforcement of, for example, people sitting on their own, or that we spoke about the first person to be prosecuted. This is a woman on her own, and she was actually made more vulnerable to catching coronavirus by the arrest of her, by keeping her in insanitary conditions, by mixing her with other people. And we see this time and time again, by the police going into a student's flat from the outside, when the police are mixing when the students are mixing together, how is that enforcement actually assisting preventing the spread of the disease? And that for me is one aspect that keeps being lost sight of. And sometimes it is not because it's lost sight of, but also because the regulations are changed in order to place the economy first. But where that happens, the government should acknowledge we are relaxing this regulation here because we consider that the economy is more important. The difficulty is that we keep seeing changes to regulations where they seem illogical, and focusing a little on the Northwest because of the connection with the Northwest with Rose Heilbron, for example, there's aspects of Lancashire, parts of Lancashire, where the infection rate is lower than some of the boroughs in London, but you have Lancashire in tier 3 and London in tier 2. Now, no doubt that's an economic decision, but be honest and transparent and say that's an economic decision. It's the same with privacy, that there has to be proportionality and balancing. What I would say on looking at how much you interfere with somebody's privacy, once you have lost those freedoms that have been fought for and are really part of the fabric of our society within the UK, they are very, very hard to get back again. And that is why I and many others are pushing back where there seems to be overreach or disproportionate interference with human rights.
So another follow-up question from this point is, how can we help people understand the difference between the regulations, the laws? With this flurry of legislation that came through, it's almost difficult for lawyers to keep track of the changes, but the population at large, they don't really understand the distinction between these tiers of legislation, if you like. And somebody who's a legal educator is saying, what can be done to help the public understand this distinction and how they work differently together?
Yes, a lot of responsibility for that lies with government, and a lot of responsibility for that actually also lies with media, because I think we've seen two things. We'd see, I gave an example of some of the government messaging from the Prime Minister. This is what you must do, and this happened right at the very start. So we were told we were in lockdown from the 23rd of March. The law actually empowering what we were told we had to do only came in on the 26th of March. And so already the government started on that path of subjecting people to the impression that what the government said was binding. And we saw police, and I've had cases where the police had followed what had been said by a minister or prime minister at press conferences, but that had not actually been the law and had been more restrictive and had led to arrests which were wrongful arrests. How do you, so the responsibility was the ministers not to do that. Whether there was, I think possibly whether there was some panic at the beginning, we can all make excuses or justifications, and we can all be flexible with that. But now, 8 months on, there really is no excuse to be mixing or confusing people with what's guidance and what is law. And similarly with the opposition, they have responsibility. I would also say that the media has responsibility, because what also has been happening, and this has carried on for many, many months, is ministers would be invited on some of the flagship news programs, and they would then explain what the new regulations are, and they would get it wrong. And then the other media outlets would pick up on that flagship outlet and then publish wrong information. And so people were confused, and people sometimes were just very scared about what they could do and what they couldn't do, quite understandably. So as to how you get clarity moving forward in the future, it is ridiculous that there are a small number of lawyers who are active on social media who are explaining this is what the law now says and this is guidance. That should never ever have happened, and this has really been lawmaking which has been very damaging to the rule of law, in that people have become more and more confused, and ultimately what we have started to see is some people just taking their own decisions, or considering some of the laws were so illogical that the logical ones they are not following, and so we're starting to see a breakdown. And whether you can set up an independent institution to try and address and make things clearer, that might be a way forward, in the way that a lot of countries do, where they have independent institutions where they are addressing facts before elections, for example. So that might be something that could be considered in future.
Thank you. And a further question. It seems to be very clear what our present will involve, especially that I understand Parliament has just passed the new tiering system. So we are where we are in the present. So let's cast our eye, not least because I'm always looking forward for what will be the theme for next year's lecture. What do you think, looking forward, will be the changes that we can expect? And somebody's asking, you know, how do we think these laws and regulations will be changed by the introduction of the vaccine, now that has, you know, we've discovered it and we're encouraging everybody to take it. What can you see in the future now that we have this development, and how can it all change for us in terms of freedom?
Yes, well, there's always a tension between laws which are part of our lives, which are telling us what to do and what not to do, and the aspect of health, of protection of people, of protecting us from those who are not going to act responsibly, and individual responsibility. Now, my view is that the government has gone way too far in taking away personal responsibility and trying really to control every aspect of our lives. And we can see this particularly in the recent, the all tiers regulations which are coming in from tomorrow. There are so many, there's so many exceptions around the different linked households. You have 3 linked households over the Christmas period, and it is complex, undoubtedly with good intentions, but it is complex. So what I would like to see happening is all these prohibitions and conditions of what people can and can't do are taken out of the law and put into public health guidance. And I'd like to see enforcement, which is fining people, which is a diversion from the criminal justice system, or prosecuting people, which is criminalizing people. I would like to see that taken out of the laws. Now, arguably you might need to look at some form of criminalization in an aggravated case, certainly. But what had happened with the stroke of the pen, we have ended up with super fines, where fixed penalty notices now can be issued at a level of £10,000 without any means testing, which is what you get if you were before a court. So the whole enforcement section needs to be looked at properly in order to bring back some kind of just and equal treatment and fairness to people. What do I see happening with a vaccine? I would hope to see the cessation of use of emergency procedure. There is no need to keep using emergency procedure, and a return to having law being debated properly, where amendments can be put forward properly and considered through Parliament. Because currently the politics and law are running side by side, as they often do when it comes to human rights. And currently the politics really is knocking out a just rule of law, because Parliament is not being able to hold the line in mediating between executive and between citizen. That has been successfully bypassed, and we actually have been for some time within an apparatus that you see of totalitarian states. The government says something, the police take that as a message and then carry out enforcement. Now, the police do not act according to government, the police act according to the law, and you've had a bypassing of Parliament. We've seen pushback from the end of September from Parliament, and we're starting to see changes. So what I would hope to see in the future is Parliament taking back control, and also Parliament finally looking at these emergency procedures in order to assess whether the Public Health Act needs reform so that it is not used in this way, and that there are new emergency procedures brought in which have more inbuilt safeguards than currently we can see is happening, because that has enabled the government to continuously bypass Parliament. I'm not putting this as a party political thing. No doubt any government in power would absolutely love to govern by decree and keep Parliament to one side. And what we have seen here is what happens when that power is available. And so that does need to be addressed.
Thank you so much for taking these questions. I think we need to start looking towards the end of the session, but I would love to welcome Hilary Heilbron to the stage to say a few words about what it means to her that we have a lecture series in the name of her mother. Welcome, Hilary.
Good evening to our virtual audience. It's with enormous filial pride and pleasure that I've listened to tonight's inaugural lecture. The series of Heilbronn lectures are a fitting tribute to my mother, her remarkable career. And Kirsty has started the series off with a most eloquent and thought-provoking and topical talk this evening. And as you heard in Mary's kind introductory remarks, it was just over 70 years ago that my mother became the first joint female KC, as it was then, and nearly 55 years ago, the first female senior judge. And these are only two of the pioneering landmarks in her stellar career, at a time when it was rare for a woman to succeed in a man's world, and particularly to do so at the same time as being a wife and mother. She began her career in the Second World War, and some of her famous cases, she's always known for her murders and her ability to sway juries, but she loved legal cases as well, and had many that went up to the House of Lords, were cases which concerned the importance of similar restraints of freedom in the context of World War II, as Kirsty mentioned, cases involving breach of the regulations where officers tried to circumvent the rule of law in the context of proper compliance with those regulations, for example, lawful arrests and matters of that sort. But coming back to the Heilbronn lecture series, it's not only a wonderful recognition of my mother's achievements, but it's also further evidence of the fulfillment of her vision for women in the working place, something about which she regularly spoke at events around the country. And I can do no better than quote from a speech she made shortly after becoming Recorder of Burnley in 1957, when she said, and I quote, "The distinction of my appointment is merely its novelty, but the achievement of which I am most proud is the demonstration that women can, given equal opportunities, compete on equal terms with men in the professions as well as in other types of work." And her view was women had to have patience, and in those days they just got on with their job. But tonight's lecture series and tonight's inaugural lecture proves her point. I've always said that I'm a barrister who happens to be a woman, not a woman who is a barrister. And I've always believed that full equality will be achieved when we no longer have to describe ourselves, describe female lawyers as women lawyers in order to promote their talents on an equal footing. When it will no longer be remarkable, but the norm for women to reach great heights in their chosen profession or career. and when it's no longer necessary to have targets or quotas. But this will undoubtedly take time, though the Heilbrunn lectures are a further very important contribution to this process. And we must thank Dana not only for this lecture series, but all that she has done in relation to the past 100 years, and hopefully in relation to many of the future 100 years to this end. My mother, I have no doubt, would have been thrilled at this new project in her name, aimed at achieving this very goal in the next 100 years. And I myself look forward to hearing many more such inspiring lectures going forward. And I thank Kirsty again for her wonderful lecture this evening.
Thank you so much, Hilary, for allowing us to use your name as well as your mother's name for our lecture series. And I'm very pleased. I mean, freedom is very close to my heart. Very few people know I grew up under a totalitarian regime. So you mentioning that, Kirsty, obviously rang very true. So to part ways tonight, and I look forward to seeing many of you to our next lecture, hopefully in person next year in 2021, but also to the many other things that we organize with the next 100 years. I'll leave you with something that Nelson Mandela said about freedom. And he said, for to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others. I hope you've enjoyed tonight's lecture, and we look forward to collaborating with you in the future. Have a lovely evening. Thank you.
Thank you.